So, India has the longest written constitution in the entire world. But what happens when a rule book, that massive, needs an update? Today, we're going to dive into the fascinating and pretty complex process of how you actually amend it. It's a real story of power, procedure, and a constant tug of war over who really gets the final say.
Think about it. Every country has its core rules, its DNA. But what happens when those rules need to change with the times? Before we get into the nitty-gritty of the process, let's just get on the same page about what a constitutional amendment actually is in the Indian context.
You see, a constitution just can't be frozen in time. For it to mean anything, it has to be a living document, one that can breathe and adapt as society itself changes. The people who wrote India's constitution, they got this. They knew it needed to be flexible, so they built that idea right into the system from day one.
Okay, so the magic number here is Article 368. This is the part of the Constitution that gives Parliament the power to amend. And it's pretty broad. It says they can add, change, or even get rid of any provision. Now, on the surface, that sounds like they can do pretty much anything they want. But, as we're about to see, that power comes with some really crucial limits.
So, how do you actually pass an amendment? Well, it's not as simple as passing a regular old law. Not even close. The process is deliberately tough, and it follows one of two very strict paths, just to make sure that any change has some serious, widespread support.
Right, so there are two different roads you can take to amend the Constitution. And which road you go down depends entirely on what you're trying to change. Is it a general rule, or is it something that messes with the fundamental relationship between the central government and the states? That's the key question.
The first path, and the most common one, requires what's called a special majority. And let me tell you, this is a high bar to clear. To pass, a bill needs the thumbs up from at least 2/3 of the members who are actually there and voting. But that's not all. That 2/3 also has to be more than half of the total number of seats in the House. This two-part lock ensures a really solid consensus inside Parliament.
Okay, but if an amendment touches on the really core federal stuff, we're talking things like the president's election, the Supreme Court's powers, or the division of power between the central government and the states, then things get even tougher. Passing Parliament with that special majority is just step one.
For any of those big federal changes to become law, at least half of all the state legislatures in India also have to approve it. This is a huge check on power, right? It stops the central government from just changing the rules of the game on its own.
This all leads to a massive question. If Parliament jumps through all these hoops and follows all these strict procedures, is its power to amend the Constitution absolute? Can it change anything it wants?
For decades, this very question sparked a fierce legal battle. If you just read Article 368, it kind of seems like Parliament has unlimited power, and that interpretation set the stage for a historic showdown between the lawmakers and the judges.
You can literally see the legal pendulum swinging like crazy. In 1951, the Supreme Court said, yep, Parliament's power is absolute. Then, just 16 years later, in '67, it did a complete 180 and said, nope, fundamental rights are off limits. This direct conflict was building towards a monumental decision that was going to reshape everything.
And the resolution finally came in 1973 in the landmark case of Kesavananda Bharati. The Supreme Court created something that's now known as the Basic Structure Doctrine, and it is probably the single most important limit ever placed on Parliament's power to change the Constitution.
So what is this basic structure? Well, the court was smart. It didn't give a final, exhaustive list. But it pointed to these core principles, things like the supremacy of the Constitution itself, a democratic government, secularism, the separation of powers. The best way to think of it is like a house. Parliament can renovate, it can repaint, it can even add a new room. But it absolutely cannot knock down the foundational pillars that hold the entire house up.
Now, this new doctrine wasn't just some dusty legal theory, oh no. It was immediately put to the test in a high-stakes, real-world clash between the government of the day and the courts. So, in 1976, during a really controversial period in Indian history known as the Emergency, Parliament passed the 42nd Amendment, and among all of its massive changes was a direct shot at the judiciary. It basically declared that Parliament's power to amend was unlimited, and no court could ever question it. But the pushback was swift. This huge power grab in the 42nd Amendment was followed by the 44th Amendment in 1978.
That, plus some later court rulings, basically reversed the most extreme changes and powerfully restamped the authority of the basic structure doctrine.
So, after this decades-long constitutional tug-of-war, who actually gets the final say? Who's in charge of the nation's rules? And the answer isn't one person or one group. It's really this delicate, carefully maintained balance of power.
The key takeaway, the bottom line is this. Parliament is an incredibly powerful engine for change. It can amend fundamental rights, it can adapt the Constitution to brand new challenges. But, and this is a huge but, its power is not absolute. It cannot destroy the core identity of the Constitution. That's a framework that is ultimately guarded by the Supreme Court.
This whole dynamic ensures that the Constitution stays a living, breathing document, but one that never ever loses its soul. It's like a permanent conversation between the will of the people, spoken through Parliament, and the timeless principles protected by the judiciary. And how that delicate balance is kept? Well, that remains one of the most vital questions in India's democracy.